Hi, good afternoon, everyone. Welcome. This is Rajiv S. Khanna from the law offices of Rajiv S. Khanna, immigration.com. This is our alternate Thursday community conference call in which we take your questions that have been posted in the forums. And then we also take the questions from people who are already here. I have a lot of people already in the call, so I'm going to have to lock the conference. I'll just wait 30-40 more seconds. I'll lock the conference and then I'll make sure that I answer the questions of people who are already here as best as I can. That would be the plan. So let me just go ahead and lock the conference now. We have more than enough people already. So security lock conference.
The conference is now locked.
Okay. So today is February 20th, 2025. Let me explain to you the format of the call. First of all, I will answer questions from those questions that have been posted on the forums already. Typically, I want them to stop at about 11 questions. I have 18 questions already today. It's too many questions. Once I have answered the questions posted, each time I answer a question, I'll invite any follow-up questions. At that point, if you folks have any questions that are follow-ups on what I just discussed, you can ask, but don't ask me any new questions. So I'll deal with the questions posted first, follow-ups on the posted questions, and then once that is all done, then we will start with all the new questions. Okay? So let me just put everybody's hands down because right now, let's see, clear queue. Okay. So beginning with the questions that have been posted, out of those, certain questions I have already marked as frequently asked questions. So let me go to those first. Let us see. First frequently asked question is question number 8. Can I volunteer with a non-profit while on any temporary visa? For example, F1 OPT. Okay. So normally, if you have an H4, for example, or even an H-1B, and you want to volunteer, for example, in a church or a temple or any kind of a religious or social gathering where you don't get paid in cash or in kind in any way, no benefits, no cash, no kind. Can you do that? The answer is sure. It's not illegal for you to work as a volunteer without getting any money. Now, F1 OPT becomes a little bit more complicated. If you are trying to set that volunteer work as a part of your compliance with the OPT program, then you have to make sure that you work at least 20 hours each week, and whether paid or unpaid, first year of OPT, nobody cares. Whether paid or unpaid, it has to be in your own major. So if you have a computer science major, you can't be working in geology. Okay? It's got to be in your own major. Let's see the question that was posted. It says, I am on F1 OPT working for a company. Am I eligible to volunteer with a non-profit related to my field involving events, etc., event organization, webinars, or in-person training? And the answer is, as long as you have at least 20 hours of work that you can prove, additional 20 hours. Now, additional work, there's a weird problem. Normally, if you are trying to use this work as a part of your compliance, then it has to be also at least 20 hours. So you'll have 20 plus 20 hours in two different jobs. On the other hand, if you're just trying to do some fetch and carry and you don't really care about this being counted towards your compliance of 20 to 40 hours, then it's fine. Just discuss it with your DSO. I certainly don't think there is a problem volunteering. Number 2, if I volunteer to review research by papers, I think that is also permissible. I don't think you're not getting paid for it and you're in your own field. I don't think anybody can have an objection about that. So, bottom lines, volunteer activity on non-immigrant visas is permissible as long as it is not compensated. Okay. But do make sure that you don't work for a for-profit company. If you work for a for-profit company, the company might be guilty of taking free work in violation of Fair Labor Standards Act. You are not violating any law, but the company might be. Okay. Can you volunteer for articles, etc.? Again, if you're not getting paid, sure, why not? I don't see any issue with that. Anybody has a follow-up question? This press *5. Anyone has a follow-up question on this? Please press *5 on your phone. Okay. There is a follow-up question from area code 614. 614, go ahead, please. Ohio.
Can I say, sir, I have a follow-up question on this one as I have been told by another firm long time ago that if you are working even on F1 or H1, if you are working for a non-profit or in your field, then it's not allowed. If you're not working in your field, in the area of your study, academics, then it's fine. But if it is somehow related to your studies, then it is not allowed.
I believe that is incorrect. I think what is the more appropriate way to describe it is this. If you are taking up something that would normally be a paid job, then it could be a problem.
So let's say if I am a mechanical engineer and somehow I am trying to work towards a firm which is non-profit, I'm not getting paid, and it's in the field of mechanical engineering. Let's say I am helping a professor in a university. I'm not getting paid. It's non-profit. So you're saying it's still allowable?
Yeah, I think it would be allowed because if you transpose that into an industrial example, let's say that you were trying to volunteer at a robotics lab, which is a for-profit organization. I think that could be a problematic situation because that's normally a paid job. Okay. But it's a non-profit, it's a research activity, it's academic. Personally, I think it should be fine.
Sure.
All right.
Thank you.
Good luck. All right, let's go on to the next frequently asked question, which is right after this one, which is 9. Options after layoff on an approved EB1, compelling circumstances EAD and green card EAD conversion. I got my EB1A approved and in the process of filing 765 and 485. My dates are current. Unfortunately, I got laid off. So what is my option? So EB1A just requires that you are going to work in your own field. You can actually file a 485 without a specific job if you have an EB1A approval. Okay? So I'm not even sure why you are not filing 485. You can do it. Can you do a compelling circumstances EAD? Oh, that is only available if the dates are not current. Okay? So I think what makes sense is to just file the 485. Like I said, if you are working in your own field, you can file a 485 with just the intention to continue working in your own field. Have your lawyers become a part of this discussion, but I feel you can file your 485 without a specific job. *5. If you have a follow-up question, please press *5. Okay. There is one follow-up question from area code 214. Area code 214, go ahead, please.
Hi, Rajiv. Sir, good morning.
Good morning.
Thanks for doing this service.
Sure.
And I have a question. So, is it something once I file 485, can I be unemployed and stay after 60 days too?
Yes.
So I don't know when I'm going to get my GC EAD. Okay.
No, you should be fine. The only time somebody could have had trouble is if there was an issue of providing an affidavit of support for your own family. But in your case, that is not an issue because you are not an immigrant. You can't even fill out an affidavit of support. So therefore, you should have no issue if you file without a specific job. Okay?
Okay. And can I apply for the job? And if they are not willing to sponsor with the pending approval for the GCAD, how come? What status can I apply and I can get the job?
You can't get a job until you get an EAD. You won't be able to get a job. Okay.
Okay.
Because if you had maintained your H-1B status, you could do an H-1B transfer waiting for the EAD, no problem. Okay. But once you fall out of H-1 status and your only claim to legal status is your pending 485, then you have to wait for the EAD.
Okay.
All right.
And can I expedite the EAD? And until I got my EAD in hand, I can be unemployed.
You can be, yes. All right.
Okay, got it. So there is no need of B1 to B2 conversion. And
No.
once I get EAD and EAP, then only I can travel out of the country for them.
Only after you get the advance parole.
Okay, got
All
it.
right. Good luck.
Yeah. Thank you, Rajiv.
You're welcome.
Thank you.
Bye.
Thank you. Bye.
Okay, let's go on to the next frequently asked question if there is one. All right. NIW I-485 rejected. Refiling options and priority date usage. Question number 1. If national interest waiver 485 is rejected, can we refile the I-485 or do we need to start a new NIW case from I-140 stage? So first of all, I almost never file 485 together with an I-140 in these cases, simply because what is the guarantee I'm going to win? And if I don't win, then I would have wasted all that money that went with the 485. So your question does not make sense because how can you file a 485 once it is rejected? How can you refile it unless you have an I-140 either pending or approved? So if your NIW is rejected, hang on, I may have misunderstood your question. I just noticed that. If NIW I-485 is rejected, so it's not the NIW that is rejected, it is just the 485 that is rejected. Can you refile? Absolutely. Do you need to? Now this question makes sense. Can we refile the I-485? Yes, you can. Or do I need to start a new NIW case from I-140? No, you do not. If your I-140 is pending or already approved, just because your 485 was rejected does not mean you cannot refile. There are some nuances here that should be discussed with your lawyers, whether there is any special circumstances that require one option over the other. So just make sure that you talk to your lawyers, but this is definitely possible, refiling I-485. If I refile new NIW and it is approved, can previous NIW's priority date be used? Well, I'm not sure again. I think your NIW is not yet approved. That's the feeling I get from this posting. Remember one thing, if an I-140 is not approved, it does not give you a priority date. So there's no question of using that priority date. Unless the I-140 was approved, there is no priority date. Question number 3, how will Trump administration affect NIW 485 cases? Would you suggest any precautions? Not anything so far. Can petitioner file multiple NIWs simultaneously with different endeavors? I have never done it, but theoretically, is there anything stopping us from doing it? I don't think so, but I think it does dilute your case, doesn't it? Because it seems like you don't have a focus. So I'm not sure it's the best thing to do, but I certainly don't think it's illegal. *5. If you have a follow-up question on this, press *5, please. No follow-up question. Okay, now let's go back and start in the order that people have posted their questions on the forums. So this is question number 2. Converting to F1 with approved I-140 and pending H-1B to B2. So I have a pending H-1 to B2 conversion and I-140 is pending. Can I convert to F1 without leaving the US? And the answer is, remember, some of you were here when we were talking in the beginning. You cannot convert or you cannot change status until the prior status is approved. So if you have, let's say, H-1B 60-day grace period, within the 60-day grace period you applied for B1, B2. Once the grace period is over, what is your status? it is not full status. You just have a B1, B2 pending. That's called authorized period of stay. If you want to change status, you have to be in status, not in authorized period of stay. What does that mean? That means you cannot convert to F1 with B2 pending. Unless B2 is approved, you cannot convert to F1. However, once B2 is approved, you can then apply for F1 change of status because your B2 is approved. And if you wanted to premium it, you could. Okay. Star 5. If anyone has any follow-up question on this, press star 5. Area code 469. Let's take you first. Then there's a person behind you. Oh, you are both from 469. Weird. Okay. 469, go ahead, please. How can I help you?
Hi, Rajiv. Yeah, hi, Rajiv. Actually, I had a similar question, but my GP wasn't done and I was laid off. And I was wondering if you convert to F1, right? Can we pursue a PERM and 140 again on F1? Because F1 has a non-immigrant this one, right? Non-immigrant category, right?
So let me clarify something. Hold on. Let me clarify something. It takes you about a year and a half to get to PERM approved stage. Maybe more, maybe almost 2 years. Okay. PERM is not considered to be a green card. Green card begins upon the I-140 stage because the question in the forms is, have you or has anybody on your behalf applied for your immigrant visa? Immigrant visa is I-140. PERM is not green card. PERM is not immigrant visa. So let's get that clear first. Go ahead with your question now.
Yes, but when I move to F1, right, and so, and if I opt for a day one CPT kind of a thing, which is a little riskier and I have to stay in the US, and if I have the employer convince and then do the PERM and then 140, I just want to skip the lottery again because I already have an H1 which is maxed out. So I was just thinking that to skip the lottery, if I do a change of status at that time with F1 to pass to H1B, will they? It's a risk and it's a denial.
Oh, I'm very confused. I am extremely confused by your questions. So, how does lottery come into this? Are you currently on H1B?
Yeah, but it's maxed out. So, and I was laid off, right? So, and there's
so hold on. If the H1B is maxed out, you cannot get back onto H1B unless you are outside USA for 1 year and go through the lottery, or unless your PERM has been pending 1 year or your I-140 is approved. Okay, so there is no question of going back onto H1B unless one of these conditions are met. I'm assuming you don't want to go outside USA for 1 year. Then you have to wait. In order for you to get back onto H1B, you have to wait until the I-140 is approved or the PERM has been pending 1 year. Okay?
Yes, I understand that, but I had that situation where PERM was pending, and I-140 was not filed, and in between I was laid off and I got maxed out. And so now I have no choice, but have to return back to the home country, and the employer is making arrangements for that. But I was thinking to move to day one CPT because I'm just in grace period right now before getting into any other unwanted status, right? So if I move to day one CPT and again pursue a PERM and 140 through a different employer, so is there a risk in doing a cost to H1B again? Because I already have an H1B earlier, right? So can I repurpose that H1B?
Yeah, hold on. So first of all, until the PERM condition is met, 1 year PERM filing or I-140 approval occurs, there is no way to get back onto H1B. Okay. The only danger there's no danger that you will not be able to convert from F1 to H1B because your green card is going on or pending. That's not an issue. Your pending green card can impact your F1 conversion, but it cannot impact your H1B conversion. Okay.
Hmm.
So that is not an issue. H-1B is a dual intent visa. You can have the intention to file a green card, have a green card going on, no issue at all. Okay.
Okay. Okay. So
Yeah.
F1 will be at risk, you're saying?
Yeah.
Okay.
It could
So
be.
in that case, it
Yeah.
would be better. Mm-hmm. I
Okay.
see. And it would be advisable to leave the country after F1 and then go through consular processing then?
I think you'll have the same problem.
Oh, so on F1 you should never pursue a green card then?
Well,
I mean,
I wouldn't say never. I think you have an exposure there. There's a risk of denial. Okay. And there is no easy solution
Yeah,
to that.
okay.
Nothing we can do about it. You're going to have to jump in and take a chance. All right.
But anyway, they'll figure out, right? Okay, this guy is using a workaround from H1B to F1 to H1B. It's just a workaround.
Yeah, what they will do is
Right.
impossible
Just
for me
take it,
to
right?
predict, but that risk is there for sure. Let me move on. Next call is also.
Okay, sure. Thank you so much.
You're welcome. Next call is also from area code 469. So let's go to 469. Go ahead, please.
Good afternoon, Rajiv ji.
Good afternoon.
So currently I am in a B2 approved status. So this is my first extension. After I got laid off, I took 6 months and then this is my first extension. I did receive RFE for it, but then post that it was approved. So in which you helped me. And now currently I'm in a situation where this ends in, this extension ends in mid of March.
Okay.
So I'm currently interviewing. I'm not sure if I'll be able to get offers like by that time.
Okay.
Maybe I'll get offers like end of March or something.
Okay.
So I have two scenarios here that I can opt for. One is I can go in for a second extension of my B2 or I can go for a F2 attached to my spouse's F1. So what would you advise for me here?
Well, my advice would be if you can, if you think you're going to get a job within the next 5-6 months, stay on B2. That's slightly better. But if that is iffy, just convert to F2. That's probably a lot better. Okay.
Okay, sir. Suppose because I have already got a RFE with my first extension.
That doesn't matter. We won the RFE, right? So what is the problem? That RFE, I don't care because that RFE was overcome.
Right, sir. So, F2 with premium processing.
Why premium? Just do non-premium. Why premium? I don't even know if there's a premium for F2. Don't remember.
Oh, okay.
All right.
Okay, sir.
Good luck, ma'am.
Okay, sir.
All right. Bye-bye.
Thank you, sir.
You're welcome. Area code 815. Go ahead, please.
Hi, Rajiv. I want to get married, but I am on a day one CPT visa.
This question has nothing to do with nothing to do with what I discussed. Wait for your turn, okay?
Sorry. Okay.
Yeah. So only follow-up questions. Please be disciplined about this. Then comes the question number 3 that has been posted. Can I include paid CPT internship experience in my PERM I-140 application? Yes, you can. Absolutely. 32 months of full-time experience, paid internship. Do I qualify for the job? Yeah, let your lawyers decide. There is no requirement in professional jobs that the experience cannot be internship experience. So that's the short answer. Any follow-up questions on this? Press *5. Okay. Let's go on to the next one. Question number 4. F1 OPT maximum stay. Oh, there is somebody. Guys, you have to hurry up a little bit, okay? Please don't wait. So I have to go back to that question. Area code 469. Go ahead, please.
Hello, Rajiv. So the internship had academic credits, but that academic credits were not used.
No, I don't care. I don't care. Even if it had academic credits, you might be able to use it depending upon the way the PERM is worded. Don't worry about that part.
Okay.
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 Good luck.
Okay. Thank you very much.
You're welcome. Okay. Then, which one was next? Okay, next question was F1 OPT maximum stay outside. I'm currently on initial F1 OPT and volunteering at my university under a professor's supervision. Due to personal and family medical emergency, I had to travel internationally. It's been around 3 months I've been outside the US. How long can I extend my stay while on F1 OPT? Well, this is a very difficult question to answer. First of all, this is my understanding, the only time your stay outside does not count towards unemployment is when it is just a couple of weeks, like normal annual vacation that the employer gives to everybody. Okay. So normal vacation given to everybody is not considered to be unemployment. However, can you work remotely from outside the country? This is unclear. Nobody knows the answer to this question. You can do it within the US, but can you do outside US? Nobody knows. Be very careful with this. And the third situation is, I'm not working remotely. I'm just attending to a personal emergency. That's definitely unemployment. So if you have 90 days of unemployment in the first 1 year, you go 91st day, you no longer have an OPT. That OPT is gone because you exceeded your allowed number of days. Yep, I think I already answered all the questions. Star 5 if you have a follow-up question on this. Press star 5 if you have a follow-up question. All right. Next question. I-485 application with class 1 misdemeanor conviction. Okay, so first of all, whenever you have a criminal issue, I want you to contact a lawyer in the state in which the crime occurred. And this lawyer should be somebody who has about 10 years at least of deportation, removal defense experience. Because this kind of criminal convictions involve an intersection of state criminal law, federal immigration law, and a bunch of cases on both sides, federal as well as a state side. Okay, so it's really somebody who's already doing that. It's a lot easier for them. So go talk to them. Would you need post-conviction relief, etc.? Your deportation lawyer would be able to tell you. It doesn't mean you're going to get deported. It just means the information that you are seeking would be in the hands of somebody who does those kind of cases. Okay. Star 5. If you have a follow-up question on this, press star 5. All right. So then, options for mother's long-term stay in the US on B2 while we move on L1. Yeah, that is allowed. So, I mean, at least theoretically it is there. If you look at the standard operating procedures, which Trump is trying to change, so they might change in the near future. But right now, if you have somebody very close in the family who's not qualified to get a derivative visa, like mom, okay? His wife can, children can, but mom can't, dad can't. Can you get them on a B2 and keep extending that? Yes, you can. That's an understood procedure. It's we've done it for many cases. Most I have done is about 5 years. So you can keep extending that. At least theoretically, the possibility exists. So we are planning to move to USA on L1. Mother has an active B2. I'm the only daughter. She's a widow. How to make? So B2 can be extended while she's here. No. Don't go in and out. That doesn't work. Cohabiting. Yeah, exactly. Cohabiting partners. So you already saw that on our website. Yeah, you might be able to get those extensions. Absolutely. Might be worth a shot. Okay. Star 5. If you have a follow-up question on this, press star 5. All right. Area code 470. 470, go ahead, I can hear you.
Thank you, Rajiv, sir. So I have one or two follow-up questions.
Please.
Let's say if I extend the B2 visa while she's in US, let's say 3 times, and after that she comes back to India, and then once she comes back, how much time she needs to cool off in India and then before she travels back? Because I would have already done like 2 extensions.
I would say at least a year.
Okay.
Yep. There's no hard and fast rule on this.
You.
Yeah,
And,
that's just my sense of things. Okay. Go ahead.
Okay. Thank you. Just one more follow-up. Thank you. You are suggesting don't go in and out, like don't stay.
Yeah,
for 5 months,
that
go
doesn't
out, come back. You're suggesting better to.
Yeah. If you are going to go in and out, then make sure you are not spending in any 12 months time more time in USA than in India. What does that mean? So if you are here for 6 months, at least stay out for at least 7-8 months before you try to come back in.
Okay.
All right.
Thanks.
You're welcome. Good luck. All right. Next question is changing status from L2Y to F1. I don't know what is L2Y. Oh, I see. Son of an L1 visa holder. Okay, or son or daughter. I came to the US in 2022 with my parents. My father is on L1. I'm dependent on L2Y visa. My father recently filed for an extension. We received a 797A that our visa has been extended to December 26. We have not traveled to India for stamping. I want to start college in September 25. I need to change to F1. What is the procedure for changing my status from L2 to F1 while in the US? So you'll need to talk to your DSO. They'll give you an I-20. You'll take the I-20 and file form I-539 along with all the required documents that are mentioned in the instructions on the form. That's how you do it within USA. My I-94 shows an admit date until January 25. Do I need to leave and re-enter? Well, when your father applied for his L1 extension, he should also have applied for your L2 extension. If he has not done so, he can do it now. Because actually, it might already be too late because you said January 2025. So if you are already out of status, that means, and that's not a good thing if you want to convert to an F1. Do I need to leave and re-enter? Yeah, you'll have to go out. I don't see how you can change your status. Please talk to a lawyer. Discuss your case fully. You never know what the finer nuances of your situation are. But certainly, if you are out of status, they are very unlikely to give you status within the United States. Should we go to India for L1 stamping? No, you could go to any country. Doesn't have to be India. Let's see. Press star 5 if you have a follow-up question. Press star 5. All right. We did this frequently, 2 frequently asked questions. So FDNS site visits, H-1B amendment for address change and premium processing for H1, H4 and EAD after January 18th, 2025. 3 quick questions. Does FDNS site visit only for third-party companies or those who have an end client? Or it can be for in-house also. Site visits can be for any kind of company. My current, I'm planning changing my residential address from 35 miles from my office to 10 miles from my office, but within the same MSA. Does this require an H-1B amendment? No. How do I check the MSA information of 2 addresses? Well, I don't think you need to, because the way they look at it, if you are approved for location X and you want to work at location Y, if X and Y are normal commuting distance, you don't need an amendment. You just need a posting at the new location, LCA posting or notice posting. Okay. So the formulation is anywhere within the same MSA is considered to be commuting distance, normal commuting distance. Anywhere 50 miles is normal commuting distance. I have 1 cases with 75 miles also. So normal commuting distance is the formulation. After January 18th, it seems like USCIS doesn't have to honor the Edda Kunni settlement. That is true. Does that mean that going forward, if H1, H4 and EAD are filed together, they won't be adjudicated premium? That's exactly what it means. So very difficult to see what the government is going to do, but they're certainly not bound by that settlement. That time is over. *5, if you have a follow-up question, please press *5. All right. Oh, there is a follow-up question. Let's go to that. Area code 614, please go ahead.
So, Mr. Khanna, regarding the FDNS, so my company doesn't have a client or something. It's an OEM. So, do they also have to be like ready for FDNS visits?
What do you mean by OEM?
It's an original equipment manufacturer.
Yeah, but you're working in-house at a company, right?
So what do you mean by in-house?
So there are two ways to work, right?
No client, no.
Yeah, one way is that this employer has sponsored your H-1B and you work from their office. That's in-house. Okay. On the other hand, there is one situation where you are working through the company at a client site, or you are working from home through the company, your employer, for a client. So when the work is for an entity other than your direct employer, it is, in my view, staffing arrangement. Otherwise, it is in-house. Make sense?
So let's say if I am a direct employee of Tesla, does it require to have my employees ready for FDNS?
Yeah, they can.
They're not habitual of that.
They can still come. Sure, they can come. All right.
Okay.
Good
On
luck.
the MSA part, I'm not sure. When I look at my county, it says within the same my residence address and my office address says in the same MSA, but that's the only document I can see on Google. But if I want to check, how do I check there?
The MSAs, there is an MSA chart. I think USCIS, Department of Labor, Bureau of Labor Statistics maintains that kind of data. But you should let your lawyers worry about it. Why are you doing it? They are the ones who are experienced to look for the right kind of information. Let them do the research.
Right, but sure. I was thinking of relocating, and my extension is due in next 3 or 4 months.
See,
so
relocation.
I was not sure.
Okay, hold on. Relocation within 50 miles does not require an amendment. Okay, and it doesn't require a pay hike even if it is in a different wage area. However, when you file an extension, you'll be redoing the LCA. New LCA, new rules. It must comply with the local salary requirements at that time. Okay?
Okay. Well, thank you.
Good luck. All right. Next question. Reactivating H-1B after switching to B2 visa and working in India. My H-1B was selected, approved, activated on October 1st, 24. Position got terminated after 1 week of H-1B activation. I don't have a visa stamped. Completed my 60-day of grace period. Changed my status to B2. Is it possible to reactive remaining H-1B? Yeah, absolutely. Absolutely. That H-1B is still yours. You only used 1 week of it. Is it possible to reinstate remaining H-1B after I work a couple of years in India? The answer is probably, because the way the law is written. Let me go back and double check I got this right. Complete my 60-day prior to I change my status to B2, which will end. If I go back to India and work in India for a year or two, is it possible to reactivate? Yeah. So I used to have an H-1B, used it for 1 week, converted to B1, B2, gone to India for a couple of years. The answer is you should be okay. You should not have to go through the lottery for the next 6 years after the H-1B was approved. Now the question is, when does that H-1B period begin? From the date the H-1B was approved or from the date it ended? So nobody knows the answer to that question. So if somebody's H-1 gets approved 24 to 27, they should have 6 years from 27 that they are not subject to any lottery problems. They can come back to the H-1B. Okay, but this is a policy statement. This can be changed. So in other words, if somebody gets approved 24 to 27, government could say it's 6 years from 24, not 27. The rule is 6 years. You're not subject to H-1B lottery. 6 years from what? And that's where the discrepancy is. Star 5, if you have a follow-up question. Star 5. And you don't need an H-1B visa stamp for this. Fibonacci, CPT delayed and denied, addressing unauthorized employment and F1 status violation concerns. Came on F1 master's degree, currently doing my second master's, day 1 CPT. Recently, there was an issue with my CPT authorization. Here's the timeline. Switched to new employer, received my work equipment, ultimately denied CPT due to an error. I fixed that error. It shouldn't happen again. After hearing of the denial, what was denied? I don't understand this. CPT request. Oh, that was denied internally by the DSO, no? After learning about the denial, I immediately informed my employer. They asked me to return the equipment. My employment was terminated. Payroll. They are required to pay me for January 31st and February 3rd to regular pay. I will also rehire starting March 3rd. New CPT will be valid. Given this situation, I'm concerned because these 2 work days will be considered unauthorized employment, would potentially show up as a violation of my F1 status. How to address this issue? So I don't think there is any good way to address this issue, no matter what we say. No good way to address this issue. Government wants to get hyper-technical, make a big problem for you, they can. I think it's a de minimis violation, very small violation. So there is no foolproof way to fix this, sorry. My new employer will be applying for an H-1B. So H-1B, of course, will save you then. If I don't get selected, I'll need to re-enroll in school. Since I'm not eligible for cap, I'm considering starting a 3rd master's program. Each program is slightly different. Do you think 3rd master's degree is advisable, or would it be better to consider a PhD program? I don't think I have any particular preferences here. I think they all are equally problematic, because somebody who's been here, first they do 1 master, then 2nd, then 3rd. I'm not sure what that looks like. Government can raise a problem for you. I see somebody's hand is up, not sure why. Area code 906. 906, go ahead. What is your question?
Yeah, it's me. So I just wanted to follow up on the first part. So that was actually resolved last week.
Achha.
My DSO asked me to ask for a start date before the payday. So, and she said, they can make a note so that it won't show up as a red flag in service. So,
I'm sorry, I don't.
Time there, but that was resolved.
Not sure I understand that. So they said ask for a start date before you started working?
Right. No, so initially they were planning to give me another start date from March 3rd, and my payroll, payday for those 2 days were February 14th. So my DSO advised me to ask for a start date before February 14th, so which my employer agreed to. So I started my job, and then my DSO said she can make a note in service so it won't be flagged as a violation.
Okay. Not
so
sure.
That was solved.
Never heard of this, but if they know what they're doing, hopefully. So tell me, what else can I help you with?
Okay. Right. Yeah. So for the next part, so you said you don't advise third masters or PhD won't.
I'm very uncomfortable with that idea because one master's after another, it looks like just a device to stay in the US and work. Okay.
Right. Does it make a difference if my employer agrees to help me with tuition?
That might help a little bit. I think it's a little better, yeah.
Okay.
All right.
Okay. Thank you.
Good luck. Okay. Question number, which one were we on? Yeah. Question number 13. B2 visa extension versus switching to F2 based on spouses. I already discussed this several times today. I think you should, if you think you are getting a job soon, when you convert from H1B to B2, if you think you're getting a job, B2 is preferable. If you don't think you're going to be able to get a job in the next 6 months, F1 is the way to go. So that's the way I look at it. Being on B2 is a little bit easier to convert back to H1B. But you will do that only if you get a job. If you think there's no hope of getting a job in the next 6 months, might as well go into a longer visa, which is like F2 visa. Star 5. If there's a follow-up question on this, press star 5. Okay, let's see. Area code 480, I guess that's Arizona. Go ahead, Arizona.
Hi, Rajiv sir. Thank you so much. So I'm in a similar situation. My question is that if I file for B2 change of status, F2 change of status, my current B2 is expiring on March 29. So it's like just more than a month, month and 10 days.
Okay.
Should I go for like a premium processing of F2 change of status or normal?
I don't even know if there is premium processing of F2 available. But as long as you get it filed within the life of your... Sorry?
No, I'm saying it is there because I was filling the application and there is an option to
okay,
do
well, great. If
F2.
I don't see the need to do premium. I would just do normal. I would just do... Because as long as you get your F2 filed within the life of your B1, B2, there is no problem because you are continuing to maintain authorized period of stay.
Okay, cool. Thank you. My only concern is that if I get a job, if I get an offer while my F2 change of status is pending, how does it work?
Well, that's a very long discussion. That's not something I can wrap up here. But I'll give you a very quick overview. Don't ask me any follow-up questions on that. You can go do the research on the web. But basically, they won't give you H1 until your F2 is adjudicated because you're in between statuses. Okay. They have absolutely no obligation to give you F2 and then give you H1B. If you are on B1, B2 pending, they said, well, we'll try to expedite if you ask for premium of the H1B. We'll expedite the B1, B2, adjudicate that and then give you H1B on top of that. But if it is in between, then you have to go outside for visa stamping. That's how it works. Okay?
Okay.
Good luck.
Thank you. Thank you, Rajiv.
You're welcome. All right. So, checking NVC after EB to NIW approval, working on TN. Canadian citizen got the NIW approved since last year. NVC has not said anything. Is there any way to check the status? Yeah, they have a mechanism to check the status. Is it advisable to work? Yeah, as long as you're in the US, you can continue working on TN. It should have no negative impact on your NIW. I don't see any problem with that. Talk with your lawyers, Bob, just to make sure there's nothing I am missing from your background. Could be I'm missing a fact or two. But overall, I don't see any problem why you can't continue working on TN even with the NIW approved. Star 5, if you have a follow-up question, press star 5. Okay. Filing green card with 4 years left on H1B and LCA home address requirement for remote work. I'm in my second year of H1B. I have 3 questions. Having green card process initiated by a genuine Desi staffing company is safe even with the new government, right? Yeah, absolutely. The law is the law. Even if I have more than 4 years left on my H1B, is it still safe to have I-140 initiated in premium? Yes. I like to get the I-140 premium process just because I want peace of mind. Third, if my LCA has only the office address as the work location, and if I visit office twice a month and work from home, same MSA, is it mandatory to have my home address also on the LCA? The answer is no, but check with your lawyers if they want you to post notices within your own home. Kind of silly, but check with them anyway. Star 5, if you have a follow-up question, press star 5, please. Okay. Question number 16. Should I refile PERM under EB2 category? I've got the priority date, rest of the world, August 24. I also have 4 years experience which qualified me for EB3. I have a master's and you could get EB2. Yeah, you can start PERM again. So it's not refiling PERM, it's starting a new PERM. Why not? I would do it. I think it's a good idea. Why take a chance? Press star 5 if you have a follow-up on this. Press star 5. I would do it. Then 17 we are already done. So this is 18, the last posted question today. Salary on LCA is different than actual salary. Consequences for employees. My visa status changed from F1 to H1B in October last year. The salary listed on my LCA was 67,000. My compensation package was 57,000 or 58,000. This was all right. I requested my company to update my salary in accordance with the LCA. They could not make an exception. So this is a violation of the employer's obligation to pay you the right wage. They were not even deducting social security taxes. It's another violation. I'm not sure what's going on. This sounds wrong. They are not providing me arrears, base pay, performance bonus, etc. If an employee was working before October 1st and continued working after their H-1B approval, but their October 1st salary was below the LCA amount, from what date should they start receiving paychecks as per the LCA? From the date the H-1B was approved. So if the H-1B effective date is October 1st, your employer has to pay the LCA salary. There is no way around that. If an employer delays the salary adjustment for 2-3 months, then refuses to pay arrears, the employer can be in a lot of trouble. That's what can happen. Visa status, I think the best way to protect yourself is file a wage and hour division complaint. So Google wage and hour division LCA complaint. You'll come to a phone number, call them up, tell them I want to file a complaint against my employer for non-payment of the wages associated with LCA. They'll get you the money back. Whatever gap there is, that's one advantage. Second advantage is it's an explanation why you are not getting paid the right salary. So it's not a status violation because it was not in your control. So filing a complaint is a good idea. If the employer delays the salary adjustment of 2-3 months and refuses to pay arrears, there are too many violations here. They should be deducting deducting taxes. If the salary listed in the LCA is 70,000 but the employer structure is at 64,000, performance bonus is not salary. It has to be guaranteed bonus. The base salary has to be met, 70,000. The only time you can add bonus is if it is guaranteed. Okay, definitely talk to the Department of Labor Wage and Hour Division. Discuss your case with them. The employer is in violation. They could be in serious trouble. Area code 551. Go ahead, 551.
Hello.
Yeah. Go ahead.
Yeah, hi Rajiv ji. So I am the one in this problem, and I tried to talk to my employer. I know that I can raise the complaint, but if I try to raise the complaint, they will definitely fire me. And
if they fire you, if they fire you because you filed a complaint, that's another violation. So at the very least, call the Department of Labor and talk with them.
Okay, but they will know that I made that complaint, right?
How will they? Well, first of all, just because you talk to a Department of Labor, they won't find out. And you can check with the Department of Labor. They usually don't divulge the identity of who filed the complaint.
Okay.
Okay.
Okay. And sir, if I wanted to go to India for a back surgery, when I'm coming back, I'll need a visa. I'll have the visa interview. So at that time, can I justify my paychecks, my salary with the offer letter, because the offer letter says it is $67,000.
Okay. I think the only way out of this is filing a complaint. There is no other way out of this, because that is what protects
sir,
you. Yeah, that's what protects you. Nothing else protects you.
Sir, I want to talk to the lawyer who filed my H-1B, but I'm not able to reach out to them. They are saying that they cannot speak to me without my employer being present, and my employer is never going to allow it. What should I do?
I already told you.
If my lawyer...
Sir, listen to me.
Yes,
I'm not going to carry this conversation on forever. I have told you what you need to do. Now it is your choice whether you want to do it or not. That is the safest thing in my opinion, and that is the most perfect defense you have. Anything else, anything less than that is not going to work for you. All right?
Okay.
Good luck. Okay, area code 757. Go ahead, sir. How can I help you, or ma'am?
Hi, sir. This is Rajiv. Thank you for taking the call. So, my wife actually had a question. She couldn't join because it was night. So, she came to US in 2014.
Okay, hold on. Does it have anything to do with what I just discussed? It does not. So, please wait. Okay, just wait. I'll get to you guys. Just wait. I'm going to put everybody's hand down, because I think you're just randomly asking me questions that are unrelated. Don't do that. Hold on 1 second. Okay. Now, let us begin with any question about any topic, press *5. Any question about any topic, press *5. Okay. Because we are done with the posted questions, I'm just going to open the floor to all new questions. So let's start with the ones that I see. First one I see is area code 815. So I see a total of 6 people with questions. First one who joined was area code 815. 815, go ahead.
Hey, Rajiv. Hey, Rajiv. I'm on a day 1 CPT visa. I want to get married. On what visa can I bring my wife? Because F2 would be the last question, that in my 5 years initial visa has expired, and on what visa will I bring her? Am I doing my master's online? And a lot of questions with my day 1 CPT university they'll ask. Or how can I bring my wife here?
You cannot.
On what visa should I?
There is no visa that you can provide her. Unless she qualifies for some independent visa, there's nothing you can do for her. Okay.
So F2 would be risky, right, if we apply that?
Definitely. Okay,
Rajiv.
All right. Good luck. Let's go to area code 757. Go ahead, please. Area code.
So, so can you hear me?
I can. Go ahead, please.
Okay. So my wife came in 2014 as a F1 student, and then she got a job. She moved to H1, her I-140 approved, and everything is done. So she wanted to go back, but she couldn't. So it's been almost a decade. And now that the visa, this interview rules changed, and there was once also she tried to book an appointment, and she kind of couldn't go. Even this time she booked an appointment. So if they go now, if she goes now, like, is there any risk with the current administrative and rule changes?
Okay, I am not sure I understand what you just told me. Are you saying she has been living in the United States without authorization, without status for 15 years?
No. She came in on F1, and then she changed her status to H1B.
Acha.
Never went back and got it stamped.
Okay.
So, and her I-140 was processed, and it is also.
But hold on. Hold on.
Yeah.
Has she ever been out of status in the US? Yes or no?
No.
Okay, good.
No.
So she just went from F1 to H1B and then stayed here, didn't travel outside. Okay. So what is the question then?
Yeah. So now she is worried if she goes to India to get her stamping done and move to H1B, with the current administration and their changes, are there any rejections or RFPs that are
Not for H1B.
getting
Look,
sent out?
look, H1B is a pretty solid visa. But the problem with H1B is there are so many other complications within an H1B. So this is an issue that should be raised with the lawyers, not with me. People who know the case, know the company, know the job. Let them tell you what the risks and rewards are. But just because you've stayed here for a long time does not mean your visa will be automatically denied because you've never violated status. So that's not a problem. Okay. Have a conversation with the lawyers. Yeah.
I mean, you were the lawyer for her part-time H1B, but I'll ask her to contact you.
Yeah. I mean, I don't know which H1B she wants to apply under. If she's, I mean, of course, if she's one part-time, one full-time, she should apply for the full-time. She should be talking to the lawyers who did the full-time. But if she's resigning that job and going on to the part-time H1B, then she should be talking to us. We'll pull her file, review the file, talk to her. Okay?
Sure. Thank you.
Good luck. Area code 815. Go ahead, please. 815.
Hey, Rajiv. I'm on a day one CPT visa. If my wife enters US on a B1, B2 visa, can I internally convert it to F2?
I think it's a very bad idea because government can take the position that when she entered on B1, B2, she committed fraud because she gave us the impression she was coming for a short visit. It was her intention to convert to a long-term F2. I just don't like the idea. I mean, theoretically people do it. It works out. I wouldn't do it. If it was my friend, my sister, I wouldn't do it.
Okay. Marriage is getting delayed like so many years.
Well, I would rather, I just don't want to take a chance with something like this.
God. But can we keep on extending B1, B2 once she's here? Is that possible? Like the I-94 usually gives us 6 months or less than 6 months expiry once we enter.
What are you trying to do? Hold on. You said it's your wife and now you're saying marriage is getting delayed. I don't understand what you're saying.
No. I mean, I want to get married and assuming I'll apply for a B1, B2, bring her into US and then convert into long F2 until my H1 is approved. That's what I...
Yeah, I don't like that idea. See, it is legal for a person to get married on B1, B2. Okay. But it may be problematic when they try to convert it to a long-term status. I'm just not very happy with that situation. It's better for you to go to, your home country. You have a visa or you don't have a visa?
Day one CPT. I'm on day one.
Or day one CPT. So you could, the only other risk I can suggest you can take is go to country like Canada or Mexico, where if you travel for less than 30 days, you don't need a visa. You still have a problem. If they don't like day one CPT, they can create an issue for you. Okay.
Yeah.
But that's those. I don't
can
think.
We keep on extending B1, B2 once she enters?
Yeah, I don't think you can do it beyond one time or so. You do it more than one time, they'll deny it.
Okay. The marriage was getting delayed, because of
I understand, but I can tell you the law. I can't run your life, right? I can tell you what the law is, what I see in the law. You have to figure out what you want to do. I think once you get on to H1B, you'll be okay. But before that, you've got this problem. I'd be careful if I were you. All right?
One last question. Since I'm also filing a VAWA,
I don't know anything about. I don't know anything about VAWAs. I don't do VAWAs. I don't deal with VAWAs. Talk to your VAWA lawyers.
Thank you.
My work is employment and business based. Okay. Good luck.
I appreciate. Thank you so much for your help.
You're welcome.
Bye. Thank you.
Area code 617. Go ahead, please. 617. Go ahead.
Hi, Rajiv. Yes, can you hear me?
I can, ma'am. Go ahead.
Okay. Currently I'm on F1 visa. I'm working for an employer in OPT, and my employer said that they're okay with filing for an H-1B. And while we were going through the process, there's something called a prevailing wage. And since my company is a startup, they say that they cannot pay me competitive market salary. And if this could be a problem, if they file for an H-1B for me, it could possibly a problem for them. If they say that my application will be rejected, even before it enters the lottery.
Yep, that is true. They cannot, not without paying you prevailing wages. Now, if your job can be remoted, you can move your house to a lower salary range, because the salary that has to be paid depends upon where the work is being performed. So if the job is in California but the employee is working from Illinois, Illinois salary has to be paid, not California salary.
Okay, but you guessed it right. The job is in California. So is there like a minimum salary that they have to pay?
Every area of the country has a minimum salary requirement. Yes. Okay. Are you a software developer?
Based on the area.
Are you a software developer? What do you do?
I'm not.
What do you do?
So I'm in the healthcare professional. So.
Because it also depends upon what kind of job it is, what is the job description, what is the job title. This is it's a very fact-bound question. What is the right salary level? What is the right salary designation? So you can talk to your lawyer, see if there's a way out. For example, for software developers, sometimes somebody could be very well designated as a programmer instead of a developer, and the salary differential is $15,000-$20,000. So that has to be assessed by your lawyers. Talk to them, see if there's a way out.
Okay. All right. Thank you. I just wanted to confirm, so this salary, that minimum salary is based on my job, and there's not a minimum salary just in general?
No. There is a minimum salary, what is called federal minimum wage, which is $7 some cents, right? But each job for each area, for each seniority level has a number too.
Okay.
All right.
Okay. Got you.
Good luck. You're welcome. Let's see. Area code 425. Go ahead, please. 425.
Hey, I'm currently on my first year OPT, and it expires on April 28th. And I came to know right now that my company isn't E-verified, and they said they have an approved vendor for which I can work as a client on a C2C. I just want to understand, can I file an STEM OPT extension with them as a future employer, because I want to continue working here till April 28th?
No.
And
Hold on.
No, okay.
Hold on.
Okay.
So, until you get your STEM OPT approval, you can be doing whatever is allowed under your OPT. Okay? But once you get your STEM OPT approval, you have to work for the employer whose 983 you filed, or 893, whatever that is called.
Yeah. Can I file for another company that I'm not working for? Suppose there is company A and company B filed for my STEM OPT extension. Can I do that? Or is it a problem?
No. So you are on OPT, you are working for company X. Okay. Company Y helps you file for your STEM OPT. While the STEM OPT is pending, can you continue working for the old company? I think so. Company X, sure.
So just to follow up on that, the current employer said they will file an H1 for me. So can I, if the H1 is picked up in the lottery, can I not file the STEM OPT? Can I wait till April 1st, even though my OPT expires on April 28th? If I get H1, I'll not file an STEM OPT extension. Rather, I will file an H1 before April 28th.
This is a very complicated question. Okay. I'm going to give it 30 seconds, but I don't have more time than that. I'm already way over my time. Okay.
Yeah.
So, remember there's a gap extension, right?
Yeah.
How does gap extension work? Gap extension says, if your OPT is expiring after April 1st. You can continue working all the way. Previously, it used to be October 1st. Now it is April of the next year. So you can continue working for 1 year. And it's not required that you work for the employer who applied for your H-1B. You can be working for any employer. However, your H-1B must be filed before your OPT expires. That means if your OPT is expiring on April 7th and you get your result in March, you have only 7-8 days to file the H-1B. Okay. So it's complicated. It can be done. Lawyers have to move fast and they have to plan better.
Okay.
So talk to your lawyers.
If it is filed before April 28th, then STEM OPT isn't required.
Yeah, because you get
cap gap.
Exactly. And if in cap gap, you can be working for any employer. They don't have to be E-verified.
Okay.
All right.
Yeah, thank you for that.
You're welcome. Good luck. Yeah, it's a little complicated, hard to explain. But sit with your lawyers, it can be worked out. Area code 412, go ahead please. Area code 412.
Hey Rajiv, I have a question. So I am currently on cap exempt H1 and my I-140 has been approved. But in the current scenario, my company is going through a merger acquisition, or it might actually be closing down also. I'm a software developer, so I'm trying to look for options. Within cap exempt, I don't even have a lot of options to switch to. So I was planning to go to H4. I have then that option, be on H4 EAD, switch jobs. But my question was, will I be able to get back to capped H1 if my future organization
absolutely
applies for?
Absolutely. So what you will do is you will convert to H4 and keep applying for lottery every year through any employer who's willing to go with you. There is nothing in law that says you can't convert from H4 to H1B if you win the lottery. Okay?
Okay. And is being on H4, going on H4 the best option, or are there other options too?
Well, that's a very long very long discussion. Is there OPT available? Are you eligible for O1? Are you eligible for some other category? That's difficult for me to predict. But H4 to H1 is no issue. H4 to lottery is no issue. Okay.
Okay. All right.
Good luck.
Thank you so much.
You're welcome. Okay. I had 2 people, now I have 3 again. I don't know. Okay, area code 480. Go ahead, please. 480. 480.
Hello, Rajiv. Thank you for taking my call.
Sure. Go ahead, ma'am.
So, currently, I completed my master's degree in software engineering.
Okay.
And I started working as a food and beverage analyst for a hospitality industry. So I just want to, my company want to know, like, what is the basic payroll and the requirements for the hospitality industry to apply for H1?
Yeah, but hold on. Your degree is in computer software engineering. How can you be working in an industry that has nothing to do with software engineering, right? So how do you get it?
Because I'm working as a analyst, data analyst here.
Oh, data analyst. Okay. That might be possible. Did you say what is the salary for something like that?
Yes. What is the pay scale for applying H1B?
That depends. Just do a Google search on this and you'll come to a website that lets you put in the data and figure out what the salary should be. Okay.
Yes, that's correct. I went through that and I realized the basic pay scale is around 60K.
Okay.
But when I discussed with my employer, he was like, in food and beverage, you can only apply for director positions. That to 140K is the basic pay. So I just want to know, is there a possibility for a data analyst to apply? And
ma'am, that depends upon the company. If they have
the requirement?
Ma'am, if they have a job for you, They can apply. If they don't have a job for you, how can they even apply? I mean, if they have a data analyst position open and you indeed are doing that job, they can apply. Otherwise, they can't.
Okay, so there will be no problem with any qualifications or requirements.
Absolutely, there's a problem.
Because
The job must require the degree that you have. Okay, if they are just
similar, right? Software engineering and data analyst, they have.
I get the feeling that you are trying to make it fit. That's just my feeling.
Okay.
I could be wrong, but don't lie about anything, because this is a crime to lie about a job description, to lie about what the job requires. That's a crime. You don't want to get involved with that unless there is a genuine job offer. And this is something you should talk to your lawyers who are going to process the H-1B. They should help you decide which category you qualify under. Okay. H-1B cannot be given for a job that does not require the degree that you have. Okay. Ma'am, I'm going to have to go on. Good luck. Okay. Area code 562. 562, go ahead, please.
Thanks for taking the call. My wife is on F1 studying at Trine University, Michigan, but she's living in Texas with me.
Okay.
And she also has her merit-based green card under processing with I-130, 131, and 765 approved.
Oh, good.
So this is her last semester, and her I-20 ends in first week of May. And we are planning to travel right after that for 2 months.
Okay.
So does she needs to apply for OPT even though having a GC EAD?
Hold on. She has an EAD. She has a 485 pending. She has advanced parole also, right?
Yes.
She does not need to be on OPT. She does not need to be on F1. She can just tell the school that I have my EAD. I don't want to be a part of the F1 anymore. She doesn't have to do any of that. So yeah, no problem.
What if the 485 gets rejected for any reason?
If the sky could fall down, we could get hit by a meteor. But a marriage-based 485 getting denied is very unlikely. You know, it's a simple process. If you are married, you are entitled, end of story. Unless there is a technical error. If there was a technical error, it would have come up. You won't get your EAD and all that. You would have gotten a 485 denial right away. So, yeah, it can be denied. But, I mean, I don't know what to tell you. Just keep applying for an H-1B if you can. F1 is not a safe bet. Okay.
So is it safe for us to travel on I-131?
I think so. I do think so. Yes, sir.
Okay. And while returning back, can we both stand in the same immigration line?
Why not? Because you are married, right? You're not trying to play any games with the government. Look, if you have anything you have doubts about, any gray areas, talk to your lawyers. Discuss it fully with them, because I don't know your whole case. You're asking me hypothetical questions. I'm responding to hypothetical questions. Is there a problem with a marriage-based person traveling on advanced parole? Absolutely not. Do you have a problem? I don't know your case. Okay. So please talk to your lawyers.
Should we stand in the immigrant line or the non-immigrant line while returning back?
I do not know the answer to that question. In my view, until you actually get a green card, you're not an immigrant. You are, but not she. Okay. So you can ask them there. I don't know what kind of lines and what the requirements are. I have no idea. Okay. Good luck.
Thank you so much.
You're welcome. Okay, last question, guys. I'm way over my time, but let's do the last question. 469, please go ahead.
Yeah, thank you. On that day one CPT, I have one question. So when I am maxed out on my H-1B, and so do we advise to pursue a day one CPT, or it's better to wait 1 or 2 years abroad?
That depends. Okay. Day one CPT is certainly not liked by the government, but it's legal. The only thing I recommend to people is, if you're going to go for day one CPT, make sure it does something for your career. Don't take a completely unrelated degree. Okay. So, for example, I had a discussion with somebody who had a degree in hospitality, Yeah, that person also had a degree in hospitality management. But he wanted to work in the software area and he had 1 year of software experience. So I told them, yeah, you could do a CPT in information systems management or even computer science if you are interested in hardcore. He worked for this database company. Okay, on I think they were on H-485. He wanted to apply for an H-1. So I told them that, get a degree in your own field.
I already have a CS degree, so.
Yeah. So if you are going to do, so I mean, what else could enhance your career? How about management? Would engineering management enhance your career, or would MBA enhance your career? So these are the things that you have to decide.
Okay.
Don't take random degrees.
Okay.
Okay.
Okay. Okay. That the costs wouldn't be like under the new administration. Costs wouldn't be denied. Right? Are they at risk? Because I heard day one CPT may be at risk.
Oh, well, so far we haven't heard any movement on it, but anything is at risk. When federal government is not secure, people are losing their jobs. Who is not at risk? Okay. So I'm going to have to go.
Thank you so much.
Good luck. Folks, good talking to all of you. I will see you again Thursday after the next one. Take care, everyone. Bye.